Sometime after I filed my briefs on appeal for both of my appellate processes, I was encouraged by an opinion that the Court of Appeals released and in which it reversed Judge Conkey's ruling in the matter of Hoodker versus several defendants, including 3 physicians. In that matter, the Court of Appeals concluded that the only evidence for Judge Conkey's favorite party were an affidavit and a deposition which were provided by the same witness and which were contradictory. It was making no sense for this inept judge to favor a party under that circumstances. Accordingly, the Court of Appeals ordered Judge Conkey to enter a ruling in favor of the 3 medical professionals. That gave me hope that the Court of Appeals might likewise reverse Judge Conkey's incompetent rulings in both of my lawsuits. Because, for example, in my lawsuit against Maria Viggers, the only evidence in favor of this criminal are the deposition testimonies by Lachlan Gentles and Amy Rano. As I have been explaining in previous segments, both testimonies have several inconsistencies and contradictions. By contrast, evidence against Maria Viggers are multiple communications among the employees of the University of Michigan reflecting the state of alarm and of annoyance that Maria Viggers was causing through her unlawful activity. There is also the evidence that Maria Viggers has engaged in other crimes such as false accusations of domestic violence and matters that disprove the relevance of her mental illness. In my lawsuit against Al Pacha, one example of weak support for Al Pacha is that first he made allegations about his reasonable interpretation of a proverb, but when I asked him during his deposition to express or to show his reasonable interpretation of that proverb, this corrupt intermediary kept giving stupid answers such as, "I don't know, I don't recall, and you are not a kid." At the same time that the events I described in the previous segment were taking place, I also engaged in ongoing legal research to take advantage of a Michigan court rule regarding what is called supplemental authority letters. In few words, a supplemental authority letter is a one-page filing whereby an appellant or an appellee directs the attention of the Court of Appeals to new rulings that constitute legal precedent, whether in Michigan or in other jurisdictions, that support the litigant's arguments on appeal. Throughout the process, I was able to file around 13 supplemental authorities for each case, which is unusually high. The opportunity or provision to file supplemental authority letters is sought to somehow compensate for the typical delay of appellate reviews. I don't know whether this provision in some form exists in other jurisdictions. In the case of Michigan, a litigant wishing to file a supplemental authority letter needs to comply with several constraints, otherwise the letter is rejected. That and the significant effort involved in searching for new authorities helps explaining why very few Michigan litigants take advantage of this provision, and they only do it once or twice. An exception is the Bank of America, which submitted a total of 5 supplemental authorities in a case that went to the Supreme Court. That's the case where the Michigan Supreme Court formulated the definition of silent fraud, which I have showed in a previous segment. Judge Conkey's rulings were so contrary to any notion of justice that it was relatively easy to run into a new authority that serves as comparison of how Judge Conkey should have ruled. Of course, the multitude of supplemental authority letters that I filed are compliant with Michigan court rules. The fact is that the Court of Appeals only rejected one of my letters because I missed one condition. The ongoing search for new authorities helped me prepare a more robust brief when it was time to bring the matters to the Michigan Supreme Court, because by then I was up to date with the most recent developments of case law in Michigan and other jurisdictions. I should also point out that when I filed my claim of appeal and brief on appeal and every document in the appeal against Al-Pacha, I also filed a motion to expedite, which had a cost of $200. By not having a work permit in the US during or while my appellate review was pending, it was in my best interest that the Court of Appeals expedite or review my case as soon as possible. The Court of Appeals didn't care about my lack of work permit, didn't care about my self-expediting efforts, and it denied my motion for unknown reasons. Also, fairly in the beginning, I emailed to the Court of Appeals, not as a litigant, but as a member of the public, a suggested formula for the purpose of prioritizing which cases will be reviewed first. The formula aims at prioritizing cases where a litigant has shown diligence by self-expediting his appeal, that is, by filing his brief well in advance or ahead of the deadline. But I didn't hear back from the Court of Appeals on this matter either. About 1 year later, the Court of Appeals finally scheduled the oral argument for my two cases. At that point, there was a third appeal because of the criminal contempt proceedings that I filed against Maria Vickers because of her violations of the personal protection order. But that is a separate issue, and that has not been scheduled as of today. In reality, only in my lawsuit against Al-Pacha, I wanted to preserve my right to oral argument. But what was most encouraging about this scheduling is the meaning that the appellate reviews will be completed within few days after the hearing. In the weeks prior to my hearing, I was looking on YouTube for videos of appellate hearings because I wanted to get an idea of how they are or what are the differences between a hearing in trial court versus one in the Court of Appeals. It turns out that they are essentially the same. Maybe the only difference is that in trial court there is only one judge, whereas in the Court of Appeals there are three. But what happens is that the litigant summarizes his legal arguments, the judges make specific questions on certain issues that are not clear to them, or to get the litigant's perspective on how certain legal doctrine or law should apply to the facts of his case. However, my experience with the Michigan Court of Appeals during that hearing was disappointing because the judges didn't make any specific question, and the only two questions I recall from them was, tell us why you should win and give us your strongest argument. But from those generic questions, you cannot tell whether those judges are familiar with the case they are supposedly reviewing. Also, in the case that was heard prior to mine, I remember the lawyer was reading from her paper notes at the hearing, and I remember the presiding judge was getting cranky at her and telling her, don't just read us your brief, don't read your paper, just tell us your argument, short and brief. And yet the lawyer kept reading anyway. This was a funny dynamic between a judge in rush and a stubborn lawyer who obviously wasn't well prepared, or who wasn't prepared enough for that hearing. A few days later, the Court of Appeals released its opinions regarding my two cases, and unfortunately they affirmed or endorsed Judge Conkey's incompetent rulings. As I mentioned at the beginning of my brief in the Michigan Supreme Court regarding the process against Maria Vickers, the Court of Appeals gives the embarrassing impression that it drafted the defendant's or appellee's brief in the form of an appellate opinion. Basically, the Court of Appeals did Finley the Idiot's job by cherry-picking bits and pieces of the evidence so that it could fabricate its fictitious version of the facts. Instead of doing that, the Court of Appeals should have considered the entire record on appeal and to assess the evidence with impartiality and with honesty. Once the Court of Appeals realizes that it has run out of its invalid and poorly thought legal arguments, then the Court of Appeals resorts to making fraudulent statements which are easy to disprove. In this segment, I will not dissect all the details of the appellate opinions because it will be very long. To give you an idea, when a litigant in Michigan files a brief in the Michigan Supreme Court, the brief cannot exceed 50 pages. The appellate opinion is 6 pages long, and my 50 pages barely sufficed to address all the incompetent aspects of, the most important incompetent aspects that the Court of Appeals incurred in its appellate opinion. It will be also repetitive because I have addressed several of these aspects in previous segments. And it will be boring to the audience if I try to explain all the legal concepts and the intricacies of the law pertaining to this litigation. In any case, if anybody is interested to read the briefs, they are available and you are most welcome to download and distribute them. Hopefully they will be useful to you in case you have to engage in a litigation of your own. What I want to do in the remaining portion of this segment is to point to some of the many fraudulent statements that the Court of Appeals made in its appellate opinions. This will show you how blatantly the appellate judges distorted the evidence and the record and suppressed the laws of Michigan. It is very unfortunate that these appellate judges dedicated themselves to rubber stamping the incompetent rulings made by crook Carol Conkey, instead of enforcing the actual purpose of any Court of Appeals, which is to review whether a trial judge made the correct ruling. The fact that the same 3 appellate judges reviewed both of my cases is indicative of their incoherence. In my lawsuit against Al-Pacha, the Court of Appeals cited a case from Michigan which states that accusations of criminal activity are considered defamation per se. But the Court of Appeals didn't cite that case in my lawsuit against Maria Viggers. Instead, in the appellate opinion regarding the lawsuit against Maria Viggers, the Court of Appeals falsely stated that I didn't plead defamation per se. However, on the 3rd page of my complaint, I am specifically stating that Maria Viggers falsely and maliciously accused me of larceny, conspiracy, and damage to personality, among other crimes. Given that clear statement that I included on the 3rd page of my complaint, a judge needs to be very negligent or shameless to deny that I pleaded defamation per se. Well, here I present to you 3 examples of appellate judges who are so negligent or shameless, the 3 of them sitting in Michigan courts. The Supreme Court of the United States has made it clear that a pro se litigant does not need to include sophisticated pleadings. The Michigan court rules never require the use of magic words or even titles in the complaint. All that is needed is that the plaintiff specify why he or she is suing the defendant, and I met that requirement by making statements such as the one that Maria Viggers falsely and maliciously accused me of crimes despite knowing them to be false. On top of that, I attached to the complaint some of the emails where Maria Viggers made her false accusations to the FBI and to the University of Michigan. Of course, if a judge does not read the 3rd page of my complaint, then he's not going to give any consideration to the incoherent, disorganized rant and raving written by Maria Viggers in her profuse emails. It also takes a huge degree of stupidity for an appellate judge to make that type of denial, such as the one that this court made here. We are talking about a litigant who took the matter to the Court of Appeals and now to the Michigan Supreme Court because that litigant didn't want to put up with the incompetent rulings that some corrupt judge made in trial court. In this context, did these appellate judges ever suspect, or did they ever imagine, that the litigant might publicly denounce and disprove these judges' flagrant lies? Or are these judges so blatant that they don't even care because they are so confident that the system will protect them no matter how corrupt they are? In this particular situation, I am not even an attorney. I have other skills. I don't need to keep cushy relations with these arrogant, insecure bureaucrats for fear that they might otherwise sabotage all the cases I handle for my clients. If these judges do not follow the law, I can make a public denouncement and disprove their flagrant lies without being concerned about having to relocate my legal practice because I have fallen off the network of influence that these corrupt judges enforce in Michigan courts. I don't need to trade off between, okay, you can make your miscarriage of justice with this client of mine, but please favor me with this criminal that I am also representing. Another false and misleading statement by these corrupt judges is that the University of Michigan suspended the work visa process after learning that Al-Pacha was sponsoring me for a green card. This psychotic revelation by the corruptissima trinitas in the Court of Appeals is judicial fraud, judicial deceit. Apparently, these judges took portions of the testimony by Luckland Gentles where he made the stupid and speculative allegation that it will be problematic or invalid for the university to sponsor me for the work visa if at the same time Al-Pacha is sponsoring me for a green card. But there is no legal or factual basis for that. I have discussed already the ruling by the Administrative Appeals Office of the Department of Homeland Security clarifying that someone is eligible for immigration benefits regardless of the number of offers of employment that he retains and regardless of whether those offers are from different employers. By consequence, there is no relevance if other employers are sponsoring that beneficiary for immigration or for work visas. Additionally, Luckland Gentles wasn't even aware that my work visa process had been suspended. He was just being speculative in his explanations. This is one instance where, for the sake of protecting unlawful or inequitable acts, the Court of Appeals engages in a juxtaposition of incorrect arguments of the law and someone's misinformed and speculative testimony, while at the same time suppresses the facts which are proved by neutral real-time evidence, such as emails that ensued during or while the events were developing. In previous segments, I have showed emails by Amy Rano and other employees reflecting that the real cause why the University of Michigan suspended my work visa process was the unlawful actions by Maria Vigers, her acts of harassment and of defamation. Even though now Amy Rano denies at her deposition that I was impaired by the acts by Maria Vigers or that my reputation was impaired, her email on April 22nd is indicative that my reputation was actually harmed. Otherwise, she would not have used the wording of unexpectedly investigating an issue relating me and the FBI. On top of that, in that same email, Amy Rano made the mention of putting this on hold in reference to my hiring process and the work visa process. Also in another email, Amy Rano wrote the fact that she notified me that the process of my hiring was paused until this has been cleared up. Under these circumstances, it is absurd for the Court of Appeals to deny that Maria Vigers has any liability or to deny that she made any damage to my prospective employment. As I mentioned in the previous segment, in early 2017, the Court of Appeals denied my 2 motions to expand the record. These are in addition to the motion I filed in trial court and which Judge Conkey denied without a hearing and while violating the Michigan court rules. In these motions, I intended to file the newly discovered evidence that resulted from the continued unlawful activity against me by Maria Viggers and my father in November of 2016. This was evidence of, among other issues, the actual malice with which Maria Viggers made her false and defamatory statements. Remember, actual malice means knowledge that the defamatory statements are false. When the Court of Appeals denied for unknown reasons the motions I filed in that court, of course I was disappointed, but at the same time I presumed that maybe the Court of Appeals was already convinced of the fact that Maria Viggers made her defamatory statements with actual malice, and therefore there was no need for additional evidence. But then in the appellate opinion, the Court of Appeals made the fraudulent statement that I didn't prove any actual malice by Maria Viggers. So this is what happens. First, the court declines to or denies me to file any evidence, which I couldn't have produced earlier because this ensued in November of 2016. And then the court blatantly makes the statement that I didn't prove any actual malice. With that corrupt mentality by Michigan judges, it will be impossible to prove any case. The appellate opinion, where the Court of Appeals favors or endorses Al-Pacha despite his flagrant fraud, trivializes matters by suppressing many of the relevant facts and by disavowing many of the laws from Michigan and elsewhere that apply to this case. My case against Al-Pacha is very similar to a case from Maryland from 1984. An employer and an employee have some negotiations, but they fail and the parties have a dispute. The employer falsely accuses the employee of making threats. Of course, in the process, the employer has some erratic or delayed behavior. And then during the judicial proceedings, the employer is unable to come up with a reasonable interpretation or a reasonable testimony as to how he interpreted the threats which he falsely attributed to the employee. Whereas in Maryland, the court favored the plaintiff after making a very careful and detailed analysis, as is palpable in the opinion that is publicly available. Here, the Michigan Court of Appeals took a simplistic approach of saying that Al-Pacha was reasonably threatened, or he reasonably felt threatened because the emails in which I wrote the proverb, "What goes around comes around," were issued in the context of a dispute. Here, the Michigan Court of Appeals ignored altogether Al-Pacha's utter inability to give during his deposition a reasonable interpretation or the way how he allegedly interpreted the proverb upon which he premises his false accusations. Remember, Al-Pacha's testimony, when I asked him about his alleged interpretation, were no smarter than "I don't know, I don't recall, and you are not a kid." However, the Michigan Court of Appeals ignored that altogether. The Court of Appeals also ignored Al-Pacha's repeated reluctance or refusals to retract or at least clarify his false and defamatory statements upon my requests. As I have mentioned, there is case law making it clear that defendant's refusal to retract defamatory statements which have been proved to be false is considered a proof of the defendant's actual malice at the time he made the statement. Another difference between the diligence and the honesty between the Michigan Court of Appeals and its very superior equivalent in Maryland is that the court in Maryland noticed that the employee had been employed for several years at that entity, and yet she never made anything that will lead the employer to believe that she will carry on with the threats that the employer falsely attributed to her. Here I also had several years of employment with Al-Pacha, and I never did anything that will lead this corrupt intermediary to believe that I will carry on with the threats which he falsely attributed to me. Whereas the Court of Special Appeals in Maryland made that remark that the employer really had no basis for believing the statements that he made, Here, the Michigan Court of Appeals simply rubber-stamped the allegations by Al-Pacha and or by the corrupt Judge Carol Conkey. There is no scrutiny in the Michigan courts. There is only an urge to commit miscarriage of justice and affirm it in the court at the next level. During Al-Pacha's deposition, he made the attorney-crafted allegation that because I was his disgruntled employee, he was afraid to be held liable to the university if I did any harm to the university's systems. I mentioned this in a previous segment that it is so stupid to even think that, given that the university was my prospective employer. I was not going to harm or sabotage my prospective employment just so that this unimportant intermediary can be held liable to my prospective employer. Now, that allegation by Al-Pacha was made only during his deposition. As I have pointed out, the employees of the university testified as to what Al-Pacha told them, and there is no mention of him being afraid of being held liable to the university. The terms under which the university employees testified are only in the sense of once I am employed at the university. There was no mention of me harming the systems of the university. So this was a belated allegation by Al-Pacha during his deposition, and there is no other evidence that will support that Al-Pacha made that statement of his alleged fear when approaching the university. Nevertheless, the Court of Appeals simply juxtaposed bits and pieces of the evidence to come up with the alleged conclusion that Al-Pacha told the university that he was afraid of being held liable if I harmed the university systems while being his employee. It is naive, to say the least, to expect that I wouldn't realize the gross juxtaposition of the evidence that these three corrupt judges are doing. Also, the Court of Appeals denied that I established a claim of defamation per se for the reason that Al-Pacha didn't accuse me of any specific crime. Again, the Court of Appeals is wrong. In Michigan, false accusations of crimes are not the only venue of defamation per se. The Michigan Supreme Court recently reminded the Court of Appeals that also false accusations or false attributions of moral turpitude are defamatory per se. Al-Pacha's fraudulent narrative on July 22nd of 2015 to the university employees constitutes defamation per se, because he falsely attributed to me a lack of moral in his narrative or in the statements which he attributed to me in the sense of influencing the University of Michigan so as to negatively impact Al-Pacha's business with the university. False attributions of lack of morals constitute defamation per se, and it prejudices me to the extent that the University of Michigan withdrew its offer of employment. Lastly, regarding the legal arguments, I want to point out is that in Michigan there is a law giving precise conditions under which an employer, in this case Al-Pacha, will be protected or immune from liabilities in court if he makes a defamatory statement about a former employee. However, the Michigan Court of Appeals ignored that piece of the legislature and instead resorted to their vague and conclusory allegations that Al-Pacha has a qualified privilege, when in fact Al-Pacha violated pretty much all of the conditions stipulated or listed in that Michigan statute. A few weeks after the Court of Appeals released its decision regarding my lawsuit against Al-Pacha, some law offices or attorneys posted articles divulging that decision. And I understand why they will do that. The scenario of an employer making defamatory statements about an employee is a potentially recurrent situation because of how background checks are performed when a person is getting hired somewhere else. However, it surprises me that nobody of them makes the remark that the decision by the Court of Appeals is marked as unpublished meaning that it does not constitute legal precedent and therefore it is not legally binding in any of the lawsuits being litigated in Michigan courts. Consequently, the chances that it will be legally binding or useful in any other jurisdiction are much slimmer. To a lesser extent, it also surprises me that apparently no attorney realizes the existence of the Michigan statute, which lists the conditions that an employer needs to satisfy in order to enjoy the qualified privilege. According to Michigan case law, when a Michigan statute is very specific as to what conduct or what elements need to be satisfied, then that Michigan statute is presumed to supersede or replace its common law counterpart. Here, as I have explained a few minutes ago, the Court of Appeals altogether ignored the Michigan statute and instead it made conclusory allegations on the basis of the common law qualified privilege. I need to make the remark that one of these authors posted her article on two websites. One of them is legalnews.com. In her article, she mentions that she was unable to reach me for comments, so I gotta make this clear. I was never approached for comments on this matter. I think this is important to clarify because the way it is stated in that article, it gives the false and misleading impression that I was avoiding any inquiries on this matter, when in fact I am eager to publicly denounce the irregularities by the Michigan judicial system, and I am eager to dispel many of the inaccuracies spread by the Michigan judicial system and by the corrupt people by which I have been affected. In fact, I became aware of this article thanks to my family, who gave me a heads up of what was being published regarding my litigation. As soon as I became aware of the article at legalnews.com, I began drafting my response to be posted as a comment on that web page. But for reasons I don't know, legalnews.com hasn't yet posted my comment. I reproduced my response in my blog oneclubofjusticize.com in case you are curious to know what inaccuracies I am dispelling that were made in that article. Another unfortunate consequence, as the appellate decision is being divulged in these other websites with essentially no critical thinking, is that now the public and the legal profession are being misinformed and confused about legal matters. Because somebody who only reads the 6 pages of the incompetent review made by the Michigan Court of Appeals obviously is unable to realize the amount of information, legal as well as factual, that the Court of Appeals blatantly suppresses or distorts. I remember that at the end of my hearing in the Court of Appeals, the presiding judge, Mark Kavanagh, congratulated both parties because we made our briefs very clear. But then, as I read the appellate opinions, I came to the conclusion that either the appellate panel was markedly inept and didn't have an understanding of the Michigan laws and how they applied to my cases, or the appellate panel was markedly corrupt by trivializing the facts in order to endorse the miscarriage of justice in both of my lawsuits. During my ongoing legal research regarding the supplemental authority letters which I submitted, I remember running into several appellate reviews from Michigan and from other jurisdictions where the matters seemed devoid of any merit. I remember saying to myself, man, I'm so glad that I went without an attorney and that I litigated everything on my own, because the way the appellate reviews were drafted, it gave the impression that the lawyers were milking or swindling their clients by filing in the courts of appeals matters which really have no merit. I thought that maybe those lawyers were taking advantage of their clients' ignorance, of course, to get legal bills coming and making profit to that lawyer. But then upon my personal direct experience with the Michigan Court of Appeals, I realized that maybe many of those litigants are additional victims of corrupt judges, who instead of conducting a serious appellate review, dedicate themselves to trivializing matters in order to force an incorrect or unlawful outcome in that lawsuit. Instead of judges Kelly, Patrick, and Mark, I wish my cases were reviewed by Curly, Larry, and Moe. Because yeah, also the three stooges are inept, but at least they will have been much more honest about their jobs than this panel of juris distorts. The fact that the Court of Appeals resorted to suppressing many of my arguments on appeal, negating the evidence or grossly distorting and ignoring many laws from Michigan as well as case law from Michigan and from elsewhere is very indicative that the Court of Appeals got nothing of substance in its task of endorsing Maria Vigor's criminal activity and Al Pacha's unlawful act.